Hey everybody. So we had this order last week on the motion to dismiss that Stephanie Jones filed against Jennifer Abel's claims. It come down quite soon before the hearing, so I didn't get to it then. It's 47 pages long. I had intended to get to it over the weekend, but I wasn't feeling particularly well, so I've marked up the sections I want to go over quickly. I try and keep the video as short as possible. Today I've got some work going on as well, so there may be some background noise, which is unavoidable, unfortunately. So please do bear with me. So the motion to dismiss the motion to dismiss was granted in part and denied in part by Judge Lyman. So let's just work our way through. I'm going to skip over all the usual background. We've heard it to death. Let's have a look. I just wanted to start actually with this footnote, which it just interested me. It's not that it has any kind of bearing, but it was just interesting. So I went back and checked it. So the footnote says the answer that admits at paragraph 3 that Baldoni was a producer of It Ends With Us, but denies that allegation at paragraph 21. So me being me, had to go and look, and this is the answer that Jennifer Abel, it's like her answer to the Stephanie Jones's claims against her. And so here is paragraph 3, which says, answering the allegations in paragraph 3 of the complaint, defendant admits that Baldoni produced, directed, and co-starred in the film It Ends With Us. So there it does say he was also a producer. Then we go down to paragraph 21. Answering the allegations in paragraph 21 of the complaint, defendant admits the allegation that Baldoni is a professional actor and director, is a co-founder and co-chairman of Wayfarer, and that Baldoni was the director and co-star of the film. Defendant denies that Baldoni was a producer of the film. So, Judge Lyman was actually quite a good catch. And I was just interested. Like I say, it has no real bearing, but so okay. So I'll go through this claim by claim. There were 10 claims. So we're going to deal with federal claims first, the Computer Fraud and Abuse Act. Okay, so to survive a motion to dismiss, the plaintiff must allege that the defendant intentionally accessed a protected computer without authorization and as a result of such conduct caused damage and loss. The damages alleged must be collectively and during any 1 year period of at least $5,000 in value. Abel alleges that during a 1 year period within the relevant time frame, her losses, including the loss of her privacy and reputational interest in and control over her personal data, the expenditure of funds to regain control over her accounts, and the legal expenses arising directly from the CFAA violation exceeded $5,000 in aggregate. These allegations are deficient. Damage is defined in the statute as any impairment to the integrity or availability of data, a program, a system, or information. And loss means any reasonable cost to any victim, including the cost of responding to an offence, conducting a damage assessment, and restoring the data, program, system, or information to its condition prior to the offence, and any revenue lost, cost incurred, or other consequential damages incurred because of interruption of service. The Supreme Court has recently interpreted that statutory language and held that the losses and damages contemplated by the statute focus on technological harms such as the corruption of files of the type unauthorized users cause to computer systems and data. Abel's only relevant allegation as to damages is that she expended funds to regain control over her accounts. That claim is conclusory and merely parrots the statutory language of the CFAA. Abel alleges no facts about what those expenses were or when and how they were incurred. So the judge is basically saying to Abel, you need to show me, what did you do to regain control of the accounts? What service did you use? Have you got receipts? Like, any invoices that you had to pay, etc. Abel's allegations do not state how the Jones party's conduct impaired or otherwise affected her computers, data, or files, and their mere access to and use of information obtained from a computer system does not equate to damage to the computer redressable by the CFAA. So the judge is saying there's a causation link missing here. Even if you were able to prove the damages, how can you prove that it was Jones that caused the damage? How is it her conduct that caused that? Likely, because of the deficiency in her pleadings, Abel has abandoned her CFAA claim in her brief in response to the motion to dismiss. So Abel didn't even address this. They didn't address what Jones said about this particular cause of action. Courts may and generally will deem a claim abandoned when a plaintiff fails to respond to a defendant's arguments that the claim should be dismissed. The court therefore dismisses count 1 of Abel's amended counterclaims with prejudice. And that's why that's happened. It's not that Jones actually put out any decent argument, it's that Abel didn't address Jones's argument. So the court deemed the cause of action to have been abandoned, which is something that they do. So the next cause of action is the Stored Communications Act. As amended by the Electronic Communications Privacy Act, which was enacted to prevent hackers from obtaining, altering, or destroying certain stored electronic communications. It contains a civil cause of action against persons who gain unauthorized access to communications facilities and thereby access electronic communications stored incident to their transmission. Jones argues that Abel's cause of action under the SCA must be dismissed because she provides only conclusory assertions that her messages were accessed while in electronic storage, as required by the statute. The SCA defines electronic storage as any temporary immediate storage of a wire or electronic communication incidental to the electronic transmission thereof, or any storage of any such communication by an electronic communication service for purposes of backup protection of such communication. Abel responds that her allegations that Jones Works accessed her communications through cloud-based servers owned by Apple are sufficient. The important distinction for the purposes of the SCA is between those communications that are stored or downloaded on a device, which are not covered by the Act, and those that are accessed while stored in a covered electronic storage facility, which are. Thus, information that an internet provider stores to its servers or information stored with a telephone company, if such information is stored temporarily pending delivery or for purposes of backup protection, are examples of protected electronic storage under the statute. But information that an individual stores to his hard drive or cell phone is not in electronic storage under the statute. Put differently, the allegedly improper use of messages downloaded onto a device does not implicate the SCA because such messages are not in electronic storage within the meaning of the statute. But conversely, emails stored on an electronic communication service provider's systems after it has been delivered, as opposed to emails stored on a personal computer, are stored communications subject to the SCA. Even accepting that accessing messages from a cloud storage facility such as iCloud would be covered by the Act, Abel has not plausibly alleged that Jones accessed her messages in that way. Abel's relevant allegations are conclusory and do not make plausible the inference that the messages accessed were in electronic storage. She pleads that Jones was monitoring and intercepting her private communications in real time via iCloud, and that messages produced to the lively parties were largely drawn from Abel's iCloud. But Abel references no messages or communications she believes to have been obtained in that manner. Her own allegations support the contrary inference that Jones Works accessed historical messages via the phone itself and not messages via the cloud. So the judge is saying that for the SCA to apply, if the communications were obtained from the iCloud, then that would meet the standard required under the statute. However, if the communications were obtained from the device, from Abel's device, then that would not, and the SA would not apply. And the judge is saying to Abel, you have not made the distinction. I mean, she's alleged that it's come from her iCloud. However, Jones also had physical control of the phone itself. She alleges that Jones Works was able to access the communications through the confiscated iPhone with the iPhone in hand, and that the unrestricted access that Jones had was to everything stored on Abel's iPhone. Abel also points to no messages that might have been accessed only by some other method other than through the physical phone itself. The only specific messages referenced by Abel in her counterclaims are from before Jones Works recovered her phone. So he's referring to a screenshot from August 22nd in which Jones Work employee reveals that they have observed messages stored on Abel's phone, which was retained by the company the day before. That makes any inference that a message was accessed via the cloud even less plausible. Okay. Yeah, so they're saying Well, in that message, the employee is saying that they saw the messages that were stored on her phone, not downloaded from her iCloud. Although the court must generally accept as true all of the factual assertions in the complaint, it need not do so where the allegations are conclusory or where they are contradicted by the complaint itself. Count 2 of the amended counterclaims is therefore dismissed without prejudice. So she can refile that one. She can't refile the first one because it was dismissed with prejudice, but she can refile that one. The next claim is the Federal Wiretap Act. The statute creates criminal sanctions and a civil cause of action against persons who intercept electronic communications. And then he goes on to differentiate between the Federal Wiretap Act and the SCA. They differ primarily with respect to the communications to which they are addressed. The Wiretap Act governs unauthorized interception of electronic communications, and the SCA governs unauthorized access to stored communications. The former applies to the continued receipt of email messages, while the latter applies to the acquisition of previously stored electronic communication. The key to liability under the Wiretap Act is the term intercept. The ECPA defines intercept as the oral or other acquisition of the contents of any wire, electronic, or oral communication through the use of any electronic, mechanical, or other device. Courts have construed intercept narrowly to require that the interception of an electronic communication be contemporaneous with the transmission of that communication. Jones moves to dismiss the claim on the basis that Abel has not alleged any contemporaneous interception as required by the statute, as she alleges that Jones viewed the messages after they were already in her accounts. Courts have held that the statutory scheme requires interception to occur while the communication is in flight, because once the transmission of the communication has ended, the communication ceases to be a communication at all. The former communication instead becomes part of electronic storage, and at that point, a person cannot intercept the former communication because the term intercept does not apply to electronic storage. Abel responds that her allegations that Jones read the messages through iCloud in real time are sufficient to state a claim. Abel has alleged that Jones and Jones Works monitored and intercepted her private communications in real time. But unlike email forwarding, Abel has not alleged that Jones or Jones Works captured any message before it reached its intended destination. Abel has not alleged that there was any point, whether on a server or elsewhere, that a duplicate was created of an original intended for a single destination. Nor has Abel provided any factual allegations to lend plausibility to her claim that the messages were actually intercepted. Her only relevant allegation, that the messages were monitored and intercepted in real time, is conclusory and tracks the requirement of the statute itself. She alleges that Jones was intercepting and monitoring all of her text exchange, including not only with her clients, fiancé, doctors, parents, and friends, but also with the undersigned counsel. Abel does not include any allegations as to which messages were intercepted and when, or by which means they were accessed on the cloud, and not from the phone itself. The sole communication she references in her pleading predates Jones taking over her phone, and thus tends to undermine her claim that the messages were being intercepted in real time. And we've got a footnote. In her answer, Abel admits to the veracity of many text messages included by the Jones parties in their complaint. Even the latest of these messages, which are not included in Abel's amended counterclaims, is from the morning of August 21st, 2024, again before the phone was taken. Even if Abel had plausibly alleged that Jones or Jones Works was reading the messages in real time as they reached her phone, that would not be sufficient under the statute, as those would already be downloaded onto the physical device, per her own allegations. Without any plausible basis for the assertion that Jones was intercepting her messages, as the SCA narrowly defines that term, Abel's allegations do not cross the line from possible to plausible. The plausibility standard asks for more than a sheer possibility that a defendant has acted unlawfully. Count 3 of Abel's counterclaims is dismissed without prejudice. So we now move on to state law claims. I'm just going to skip over a lot of this because I'll be here all day reading it all. So I think we're dealing with privacy and false light claims first. So Lyman actually starts out by sorting the jurisdictional arguments. So the fact is that might therefore overcome the presumptive rule that the locus of the tort is Abel's domicile in California do not exist as alleged here. Therefore, this court will apply California law to the invasion of privacy and false light tort claims. As to the remaining tort claims, Abel argues that California law applies, and the Jones parties argue that the claims should be dismissed under either New York or California law. In the absence of a strong countervailing public policy, the parties to litigation may consent to, by their conduct, to the law to be applied. The court therefore applies California law not just to the invasion of privacy and false light claims, but to the remaining state law causes of action as well. So judges applying California law to all state claims. Okay, so first we have California Penal Code, Section 502. Jones first argues that Abel has failed to state a claim because she has not alleged a scheme and artifice to defraud as required by the statute. That argument is without merit. The statute clarifies in Section 502 that liability is imposed for accessing data to either A, devise or execute any scheme or artifice to defraud, or B, wrongfully control or obtain data. California Penal Code 502. That Abel has not alleged a scheme to defraud says nothing about whether she has sufficiently alleged, as contemplated in Part B, whether the Jones parties accessed her phones to wrongfully obtain or control her data. The Jones party argue that Abel's allegations under the California Penal Code must be dismissed because she had not alleged a sufficient connection to California. Abel responds that she is a California resident, that the phone was seized and its data accessed in California, and that therefore the acts occurred, at least in part, in California. It is true that the Jones party argue the cited paragraphs do not specifically state that her phone data was accessed in California. But at the motion to dismiss stage, the court is required to make all reasonable inferences in the plaintiff's favour. The Jones parties also argue that Abel has not alleged the kind of damages required by the statute. Compensatory damages contemplated by the statute include but are not limited to any expenditure reasonably and necessarily incurred by the owner or lessee to verify that a computer system, computer network, computer program, or data was not altered, damaged, or deleted by the access. Abel's allegations as to damages include that, as a result of Jones's malicious scheme, Abel's life has been turned upside down. Her career and reputation has been destroyed, her private information leaked, and her email inbox and social media pages filled with a daily stream of death threats and abuse. That is sufficient. Abel here has also more concretely alleged that she has spent time restoring her phone number and iCloud information and investigating the unauthorized access. Abel has adequately alleged knowledge of, on behalf of the Jones parties, that their access to her phone was without permission. She alleges that she provided her passcode for only the limited purpose of facilitating the transfer of her number, and that afterwards the Jones parties could access her phone only because they retained access to her iCloud account without her permission. Furthermore, she alleges that because they had the iPhone in hand, the Jones parties could bypass the password protection that would otherwise bar their access. Those allegations must be read together, too, with others in her counterclaim. For example, that using a personal phone at a public relations job is common practice, and that Jones Works had no policies that gave it the right to monitor her phone, and that her willingness to port her personal phone number into her work phone was predicated on her reasonable expectation that she would retain sole and exclusive access to its contents and her private data and accounts. Abel had no reason to believe Jones Works would attempt to access such data, or she would not have turned the device over without making prior arrangements to secure it. Despite lacking Abel's consent to access, review, or disseminate these communications, Jones and Jones Works were able to do so. Taken together, these allegations plausibly give rise to an entitlement of relief. The Jones party's motion to dismiss the fourth cause of action is therefore denied. So this cause of action stands. It has not been dismissed. Invasion of privacy. Abel next claims that Jones Works and Jones violated her privacy by hacking into her personal communications without authorization. To state a claim for intrusion upon seclusion under California common law, a plaintiff must plead that 1. A defendant intentionally intruded into a place, conversation, or matter as to which the plaintiff has a reasonable expectation of privacy, and 2. The intrusion occurred in a manner highly offensive to a reasonable person. Intrusion under California law means that the defendant penetrated some zone of physical or sensory privacy or obtained access to data by electronic or other covert means in violation of the law or social norms. and the expectation in privacy must be one that is objectively reasonable. An invasion of privacy claim under California law is treated similarly and requires a plaintiff to show that they had 1. A legally protected privacy interest, 2. Maintained a reasonable expectation of privacy, and 3. The intrusion is highly offensive. Since the claims are similar, courts consider the claims together and ask whether 1. There exists a reasonable expectation of privacy, and 2. The intrusion was highly offensive. The Jones parties argue that there can be no tort here because there was no reasonable expectation of privacy. Abel voluntarily ported her personal cell phone number into her work phone, which was a company-owned device. Although Abel consented to porting her phone number to and using the work phone, it is nevertheless plausible that employees in the public relations industry, similarly situated to Abel, objectively retain a privacy expectation in the content of a work phone. Even in cases involving employers' search of an employee's work computer, courts have held that under certain circumstances, employees have a reasonable expectation of privacy in the contents of their work computer. Abel explains that it is common practice for public relations firms to assume the cost of their employees' phones and phone usage. And unlike a standard work phone or work computer, Abel's work phone was configured with her personal Apple ID and populated with all of her personal email accounts, photos, text messages, third-party apps, etc. Further, she alleges that Jones had no internal policies that prohibited such personal use, and she had no reason whatsoever to believe that Jones' works ownership of the physical device would or could in any way compromise her right to privacy in the personal data or accounts stored or accessible from it. There was nothing that divested employees of a reasonable expectation of privacy in relation to such use. She also alleges that at no point during her tenure did Abel consent to anyone at Jones Works accessing, reviewing, or monitoring the contents of the device. Jones Works did not have a policy in place affording them the right to do so. Jones and Jones Works focused on the fact that Abel provided the phone and its passcode to Jones upon her leaving. But again, she only did so under the alleged promise that they would use the passcode to release her phone number. According to her allegations, she did not at that point voluntarily surrender the personal data contained on the phone. She operated under the assurances of Jones Works employees that they would uphold their agreement that upon her termination, her personal phone number would be returned, even though the physical phone would remain. In sum, plaintiff has at least raised a plausible inference that she had a protected privacy interest in the relevant communications. The Jones parties argue next that even if she had a reasonable expectation of privacy in her work phone, her allegations as to the use of those messages was not sufficiently offensive. Offensiveness is an indispensable part of the privacy analysis, as it reflects the reality that no community could function if every intrusion into the realm of private action gave rise to a viable claim. Taking into account all of the pertinent circumstances, Abel has failed to state a claim. She argues that the accessing, reading, and disseminating of her private communications and personal data for the purpose of humiliation and harm could be found by a jury to be highly offensive. However, she does not plead facts to support her conclusions. the possibility that Jones Works may have reviewed her text messages sent to a cell phone which it owned and controlled without more is insufficient to establish an offensive use. Abel alleges that at least some of the communications were shared with the lively parties and that some messages were released pursuant to a sham subpoena. However, she does not allege facts to support the contents of the messages that were viewed or shared were private. These messages are conversations with co-workers and clients that pertain to her public relations work, stored on her work phone. The most specific allegation in Abel's complaint on this issue is at paragraph 67, which includes a screenshot of a communication between Abel and a fellow employee. But the content of that message indicates that the Jones parties shared with the employee what Abel had been saying to others about working with the employee. That message does not lead to the inference that the Jones parties viewed or shared intimate information about Abel or information about Abel's personal life. Moreover, the common law invasion of privacy by public disclosure of private facts requires that the actionable disclosure be widely published and not confined to a few persons or limited circumstances. Abel's unsupported allegation that they were disseminated in the office is not alone sufficiently offensive. Although offensive use of the private information access is not an absolute requirement under California law, merely pointing to a risk that others had access to her personal messages does not state a claim. Abel's allegations as to offensiveness are also not consistent with those California courts have found to constitute an invasion of privacy. At base, Abel does not specify what information was accessed and read from her work phone. In the absence of such allegations, the court cannot infer that the sharing went beyond what would be permissible under the circumstances in which the information was shared, and thus that the Jones party's intrusion would be highly offensive to a reasonable person. Abel also brings a false light invasion of privacy tort claim. False light is a species of invasion of privacy based on publicity that places a plaintiff before the public in a false light that would be highly offensive to a reasonable person, and where the defendant knew or acted in a reckless disregard as to the falsity of the publicized matter and the false light in which the plaintiff would be placed. A false light claim, like libel, exposes a person to hatred, contempt, ridicule, or obloquy, and assumes the audience will recognize it as such. Abel argues in her brief, responding to the motion to dismiss, that the Jones parties selectively disclosed her private communications to create a misleading impression of Abel's involvement in a supposed smear campaign, which Jones Works knew was false. However, her counterclaims contain no such allegation. The closest they come is at paragraph 93, in which Abel alleges that the messages revealed were modified with slicing, dicing, cherry-picking, massaging, and in some cases outright alteration. Absent any non-conclusory allegation as to the false light cast on Abel, she cannot state a claim. Abel's fifth and sixth cause of action is therefore dismissed without prejudice. So she can bring them back as well. Conversion. For her seventh cause of action, Abel alleges that she has a possessory interest in her phone number, which she provided to Jones Works with the understanding that she would retain use of it and that it would revert back to her upon her departure from the company. Abel continues that Jones and Jones Works committed the tort of conversion when they took possession of the phone number and refused to release it to Abel when she demanded its return upon her termination from Jones Works. The Jones parties argue that Abel had no cognizable ownership interest in her phone number that could give rise to a conversion claim, that she voluntarily transferred the phone number to a phone owned by Jones Works and to a Jones Works phone plan, and that she suffered no damages. On the first of the three requirements to state a conversion claim, courts have only just begun to address whether a phone number is something to which a possessory interest attaches. To determine whether such a property right exists, California courts make a three-part inquiry. First, there must be an interest capable of precise definition. Second, it must be capable of exclusive possession or control. And third, the putative owner must have established a legitimate claim to exclusivity. Sorry, I am losing my voice. As alleged, Abel's phone number satisfies these three criteria. First, the phone number is well defined in that it is singular and the unique identifying digits correspond only to that phone number. Second, a phone number is also capable of exclusive possession or control. Jones alleges that she has a possessory interest in the phone number and that upon joining Jones Works in 2020, she had owned, controlled, and used the phone number for approximately 20 years. I think that was supposed to say Abel alleges that she has a I'm struggling with this one. Possessory interest in the phone number. I think that was a typo, and that's supposed to say Abel and not Jones, because otherwise the rest of the sentence does not make sense. So I'm going to reread that. Abel alleges that she has a possessory interest in the phone number and that upon joining Jones Works in 2020, she had owned, controlled, and used the phone number for approximately 20 years. Yeah, that makes more sense. To that end, Abel has established also that she has a legitimate claim to exclusivity. Nowhere in their briefing do the Jones parties argue that while Abel's number was ported onto the company phone, it could somehow be used by anyone other than Abel or was affiliated with anyone other than Abel. The Jones parties point to several courts that have considered whether a phone number is property and have found that it is not. These cases, which do not interpret California law, do not change this court's conclusion. Even if a telephone claim could qualify as a property right subject to a conversion claim, the Jones parties argue that Abel's claim nevertheless fails because she transferred the phone number to Jones Works voluntarily. That argument is inconsistent with the facts as pleaded. Abel alleges that she ported her personal phone number onto her work phone on the understanding that it would revert to her upon her departure. She made clear that upon her departure, she no longer consented to having her personal number ported to her work phone and requested that it be returned to her as soon as possible. Abel's porting of her personal number onto her work phone can thus be conceived as a bailment, under which California law is the deposit of personal property with another, usually for a particular purpose. Abel ported her number to her work phone for the particular purpose of its use thereon until she departed the company. And at the point Jones Works retained that number, in violation of that permission, it was a conversion of the bailment. Therefore, even though Abel did permit her phone number to be ported onto the work phone for a specific purpose, when that purpose was exceeded, the bailee in possession of the bailment is liable to his bailor for its conversion. Finally, the Jones parties argue that Abel has only conclusorily alleged damages, noting that she has suffered damages in an amount to be proven at trial. Under California law, damages are an element which must be alleged to state a cause of action for conversion. Although state law governs this claim, the federal rules of civil procedure still govern in federal court, and thus the damages element of the conversion claim need to be pleaded under the standard from Rule 8. Abel alleges that her inability to access her phone number cut off her access to critical accounts protected by two-factor authentication, and that it took her over a month to regain control over all her accounts. However, conversion damages are calculated based on the detriment caused to the plaintiff and are presumed to be the value of the property at the time of conversion with interest from that time. It is a plausible inference from the counterclaims that Abel expended time and money in pursuit of retrieving her phone number. The Jones party's motion to dismiss the seventh cause of action for conversion is therefore denied. So that claim did not get dismissed and remains. Now we have emotional distress claims. So causes of action 8 and 9, 8 being intentional infliction of emotional distress and 9 being negligent infliction of emotional distress. To state a claim for the intentional infliction of emotional distress, Abel is required to allege that there has been 1. Extreme and outrageous conduct by the defendant with the intention of causing or reckless disregard of the probability of causing emotional distress. 2. The plaintiff has suffered severe or extreme emotional distress. And 3. The defendant's outrageous conduct was the actual and proximate causation of the emotional distress. Liability for intentional infliction of emotional distress does not extend to mere insults, indignities, threats, annoyances, petty oppressions, or other trivialities. And severe emotional distress means emotional distress of such substantial quality or enduring quality that no reasonable person in civilized society should be expected to endure it. And these two claims were the ones that Blake Lively voluntarily withdrew from her complaint against Wayfarer. She didn't want to part with her medical records. The negligent infliction of emotional distress, on the other hand, is not an independent tort, but the tort of negligence. Therefore, the traditional elements of duty, breach of duty, causation, and damages apply. Whether a defendant owes a duty of care is a question of law. Its existence depends upon the foreseeability of the risk and upon a weighing of policy considerations for and against imposition of liability. The Jones parties argue that Abel has not met the high bar for emotional distress necessary to plead either its negligent or intentional infliction. Abel alleges that she was in panic and despair after Jones Works failed to release her telephone number. She alleges too that her life has been turned upside down and that she lives in fear of what is to come, given the vast troves of personal data in the possession of these hostile actors. As a result, she alleges suffering extreme emotional distress and mental anguish. The allegations are not sufficient to state a claim. First, it is not sufficient that Abel subjectively experienced emotional distress. The test has an objective component. The emotional distress must be of such substantial quality or enduring quality that no reasonable person in civilized society should be expected to endure it. Here, Abel cites the revelation of messages concerning internal work relationships and her professional engagements with Jones Works clients. These are not far outside the realm of what might be expected in civilized society. As to messages with her fiancé, doctor, or legal counsel, Jones makes no plausible allegations. Jones. I think that's supposed to say Abel. Abel makes no plausible allegations that these messages were viewed by the parties internally or shared publicly. It would make no sense if Jones didn't make the allegation. Simply stating that Jones had been intercepting and monitoring such messages with further development. The alleged disclosure of those work messages is not sufficient under the exacting standard for emotional distress claims. Jones and Jones Works argue also that even if she could meet the objective standard of distress, Abel has failed to allege that she was subject to sufficiently outrageous conduct to state a claim under California law. Abel alleges that Jones and Jones Works had access to everything stored on her phone and shared her private messages with the entire office, mocking and disparaging her. She alleges that Jones Works monitored her communications and that she lives in fear knowing that they have access to that data. She further alleges that Jones humiliated Abel by announcing per her psychic that Abel would soon be pregnant with twins. And that she and that she referred to Abel as a 12-year-old drama queen. Finally, Abel alleges that it was only under duress that she signed documents given to her by lawyers that would permit them to access her laptop. As discussed elsewhere in this opinion, Abel's allegations as to interception and monitoring are conclusory, without any further elaboration on what was monitored by who or when, or what was intercepted by who or when. This court cannot draw the reasonable inference that the defendant is liable for the misconduct alleged. And that's a fair point. I feel like that's a fair reasoning. Her allegations collectively are also insufficient. As California courts have held, it is not enough that the defendant has acted with an intent to inflict emotional distress, or even that his conduct has been characterized by malice or a degree of aggravation which would entitle the plaintiff to punitive damages for another tort. Liability has been found only where the conduct has been so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in a civilized community. Abel's 8th and 9th causes of action are therefore dismissed without prejudice, so she can replead them. I will just say it's a very high bar. It's an incredibly high bar. I haven't highlighted it, but you can see, I'll read this bit. To that end, California courts have found that allegations that an employee had falsely accused a fellow employee of committing a sexual assault in a report to a nurse and the employer's human resources department insufficient to constitute extreme and outrageous conduct. So false allegations of sexual assault were not considered enough to hit the bar. That's how high it is. And then we've got the 10th and final cause of action, promissory fraud. Promissory fraud permits a plaintiff to state a cause of action in tort when a defendant fraudulently induces him to enter into a contract. As a subspecies of fraud and deceit, promissory fraud requires proof of 1. A promise made regarding a material fact without any intention of performing it. 2. The existence of the intent not to perform at the time the promise was made. 3. Intent to deceive or induce the promisee to enter into a transaction. 4. Reasonable reliance by the promisee. 5. Non-performance by the party making the promise. And 6. Resulting damage to the promise. The specificity requirement means a plaintiff must allege facts showing how, when, where, to whom, and by what means the fraud occurred. Abel's fraud claim is based on her allegations that Jones Works induced her to hand over her company phone on August 21st, 2024, on the promise that it would return her personal phone number to her, but that Jones Works breached that promise. She alleges that Jones Works never intended to perform the promise when it was made, and that the company intended to, and did, dupe Abel into giving up the iPhone and passcode so as to access, copy, and disseminate without authorization the private data stored on the device and information from accounts accessible from the device. The Jones parties argue that Abel could not have been duped into returning the iPhone as it was a device owned by the company. That argument is a red herring. Abel acknowledges that Jones Works owned the physical device, but her claim is that she was duped into returning the iPhone in advance of wiping the personal information from her phone, deregistering her personal iCloud and email accounts, and securing her personal and private data. Abel does not allege that she owned the phone, but rather that, absent Jones Works' promise, she would have only returned the phone after removing her personal data from it. Jones next argues that Abel's claims as to promissory fraud are fatally vague. A plaintiff must plead facts explaining why the statement was false when it was made. In other words, fraudulent intent cannot be proven by simply pointing to the defendant's subsequent failure to perform as promised. Abel here alleges that Jones Works never intended to perform the promise. Alone, that allegation would, for the reasons given above, likely be conclusory. However, she also alleges that the promise was repudiated almost immediately after it was made. She states that Jones Works gave express confirmation that it would release the phone number if she went straight to Verizon, but that it did not do so, and after hours, she left the store in panic and despair. California courts have found that such hasty repudiation of the promise, or even a failure to even attempt performance, is the kind of circumstantial evidence that a court may rely on in making inferences in the plaintiff's favor. The court may also draw such an inference from the fact that Jones Works assured Abel and Verizon that they were in the process of effectuating the release, and to bear with them for a few minutes upon her arrival at the Verizon store. That allegation is indicative of continued assurances after it was clear that Jones Works would not perform. In sum, Abel does more than pointing to a defendant's action noting that the content of the action conflicts with the current state of affairs, and then concluding that the statement in question was false when it made. At least at the pleading stage, she has alleged enough to push from possible to plausible the inference that Jones Works intended to repudiate the promise when making it. Finally, the Jones parties argue that Abel has not sufficiently alleged damages as required for promissory fraud. Misrepresentation, even maliciously committed, does not support a cause of action unless the plaintiff suffered consequential damages. As discussed, Jones Works owned the physical phone, so Abel cannot claim damages based on the value of the phone itself. Instead, she alleges just that, as a direct and proximate result of the alleged promissory fraud, Abel was harmed. In her brief, in opposition to the Jones party's motion, she points also to her allegations that the lack of a phone number cut her off from accounts protected by two-factor authentication, and that Jones Works' retention of her phone gave it access to her personal information. The allegations as to loss are largely conclusory, as Abel does not point to any specific losses caused by the fact that she could not use two-factor authentication. And as she alleges, the proximate cause of public disclosure of any messages that resulted in damages was the subpoena issued in conjunction with the alleged sham lawsuit. Abel's allegations did not permit the court to make a plausible inference that she suffered damages caused by the actions she took in reliance on the defendant's misrepresentations. If Jones Works was not going to return the phone number to Abel promptly, nothing about the promise that induced her to turn over the physical phone could change that. Abel would have been required to turn over the company-owned phone regardless. Thus, Abel would have suffered the alleged damage even in the absence of the fraudulent inducement. And so, causation cannot be alleged and a fraud cause of action cannot be sustained. Plaintiff's 10th cause of action is accordingly denied without prejudice. So she can replead that. Conclusion. The motion to dismiss is granted in part and denied in part. The Jones party's motion to dismiss the first course of action is granted with prejudice. Their motion to dismiss the second, third, fifth, sixth, eighth, ninth, and 10th causes of action is granted without prejudice. Their motion is denied as to the 4th and 7th causes of action. So Abel has until October 31st, which is the anniversary of the metadata, to replead the dismissed causes of action addressing the deficiencies elaborated in this opinion. I feel like, an amended complaint against Stephanie Jones on Halloween is very poetic. Yeah, we'll go with that. That was going to end up being a longer video than I was planning, but there is so much, and I did want to try and explain as where I could the legal standard and how the judge applied it. Personally, I don't think that what he has said is unfair. I don't see this as a decision where I roll my eyes into the back of my head and think, right, okay, he's given her everything she wants again. This is Stephanie Jones. This is not Blake Lively. But his reasoning at each point, I think, is fair. And he's, for the most part, all but one cause of action, he is allowing her to replead the claims. And he has basically told her, this is what I want. This is what I want to see from you to make this stick. So hopefully we will see a much stronger amended complaint from Jen Abel. And remember, this is just Jen Abel's claim. This is not Wayfarer's claims against Stephanie Jones, only Jen Abel's. So I hope you've enjoyed it, and I will see you at the next one. Thank you. Bye.